Good evening, this is John Milburn for Laws 13010, Evidence and Proof. This is week 11 of Term 3, 2018-2019. We are very much towards the end of the unit. Thank you very much for joining me each week. We have a good roll-up again tonight, so thank you. I do appreciate when people take the time to join live. If you are watching this as a recorded session and you haven't joined us for a live session, we will be here online next Thursday for week 12. That's our final session. So please try and book out your diary to join us and we can share some information. Next week, I'll be wrapping the unit up. I'll be talking about some of the practice issues associated with evidence and proof. And of course, we'll be having some discussions about the examination. Now tonight, I need your thinking caps well and truly on. So ready to concentrate hard. And the first thing that I'll do is give you a tip. And this is really nothing new. There's nothing novel about this tip, but it's where I encourage you to have your own dictionary, if you like, your own toolkit. Those of you that have worked with me in subjects like Introduction to Law or Statutory Interpretation will know that I'm very much a fan of toolkits. And by that I mean having some easy way that you can recognize material and put it into an order that makes sense for you. Now, there is no one right way of doing things in law. You can see that by the way that judges write their decisions. They have a different approach in many instances, and sometimes people, judges or others, will rely on cases more than statutes and vice versa, and sometimes they will extract different information from a section or a case. So there's never going to be a single way of doing it. It's not maths. So as part of your exam preparation, please put together something that makes sense to you in what you believe are the critical areas of practice. If you go further, you'll actually write draft answers that you can take in with you if you think that you can anticipate what the exam questions might be. Part of the preparation, I think, involves having a definition for key words, couple that with a reference to key legislation relevant to that word or that phrase, and finally have a reference to critical cases. You really generally only need one or two to get through an examination. And indeed, in practice, it's that critical one or two that's important. If you come to answer a question in relation to the distinction, for example, between credit and credibility, then you probably are going to refer to maybe one or two cases only. There's no point giving me other cases where courts have simply applied the general principle that might have been established earlier. So I'm really looking for the lead case or cases and, of course, the relevant statutory provision. Now, as usual, if we have any questions, please feel free to unmute your microphone or use the chat facility. So, what is the difference between credit and credibility? Credit relates to the character of someone. Credibility is what we might call their believability whilst giving evidence on an issue of fact. Now, there's quite a difference. So, for example, a person who is co-accused in relation to serious criminal matters may generally not have much credit if that person has a long criminal history. As in terms of that person's character, you wouldn't say it's good. It may well be that the person has generally bad character. But when it comes to that person up on the witness box, giving evidence about what happened on the night of the armed robbery, implicating the co-accused and mapping out step by step exactly what happened, you might say that that person is believable. In other words, even though they've got bad credit, when it comes to their credibility in giving evidence on that occasion, you might say, well, they're believable, bad person, but I believe what he or she is saying, therefore will give credibility. So there's a distinction there. Just be aware of that and have something mapped out. Another distinction that we come across is to do with character versus propensity. And that leads me now into a series of cases that can, at first instance, appear to be very confusing. We'll try to drill down to the important principles. We're dealing with now with character, propensity, similar facts, an area that is a bit tough. All right, let's go in just easily and distinguish between reputation and character. And what you've noticed is already we're using different terms. And that's why I think it's important that you map out in your own mind what we mean by these different terms. Now, the reason I've introduced this segment as character versus propensity and then quickly changed to talk about reputation versus character is that which we see in the common law is not necessarily reflected in later decisions or in statutes. But at common law, when we talk about one's character, we really talk about two things. One is that person's reputation in the community. And the second way that it might be used is by talking about that person's behaviour in the past. Now, it might be the same thing, but not necessarily. You see, the second one, when we're talking about behaviour in the past, is what we call propensity evidence. And the rationale behind it is, look, if that person has behaved in a certain way in the past, they have a certain propensity to act in this way, and therefore there's more likelihood that the person will act that way in the future or as charged. But there's this basic distinction then between, at common law, between someone's reputation generally and someone's proven behaviour in the past. A really good example, and this is in your text, is Donaldson against Western Australia. It's a 2007 case, 176A Crim R488. You don't need to read the case generally, but just the very basic principle. So Donaldson was a swimming coach, accused of a series of sexual assaults against the swimming squad members. The court held that his general reputation as a swimming coach is of very little value. There is an element of who cares about his general reputation. Is that right, Michael? All right, I won't repeat what Michael said, but those of you watching the live session can read that for yourself. Do you want to share anything there, Michael?
Oh, I didn't know. I didn't know because I took off to the army not long after, and then it rings some form of a bell that I heard something, but then it came out. And it's funny because you talk about it, and if I was around, I most probably would have, theoretically could have been called, and you don't know. So your character doesn't go anywhere. You know the person trains you for years. You don't know. So it can't carry. It just proves it.
It happens. And I guess I'm not disclosing too much. My son was a swimmer for many years, so I got to know the coaches very well. So it's a difficult gig being a swimming coach in that sense. But there was that element of, well, who cares if he's a good swimming coach? However, evidence of him having behaved with propriety towards female trainees is a different matter, because that's evidence of his behaviour in the past relevant to the charge. It's a pretty grey area. It's a pretty fine line. But generally speaking, when we talk about propensity, and you know what I now mean by propensity, behaviour in the past, the general rule is that it's not admissible. It's a matter of fairness, isn't it, to the accused person to say it's not admissible. The leading case at an early stage was the case of Pfennig, Pfennig, Pfennig against the Queen. It's 1995, 182 CLR 481. And the High Court said in the mid-90s in Pfennig that propensity evidence is not admissible if it only shows the accused had a propensity or disposition to commit a crime. The rationale in simple terms is to use a quote that we hear often, is that the probative value does not outweigh the prejudicial effect of that evidence. So Fennig, generally propensity evidence is not admissible, only if it goes to show a propensity or disposition. But now we have another distinction that I need to draw, and that is the distinction between that which is mere propensity and that which is similar fact evidence, which is kind of propensity, if I could say, but on steroids. I'm using very basic terminology here to try and draw the distinction and make a point. So general propensity, Fennig, not admissible. Similar fact evidence might be. Depends on how close and it depends on the quality of the probative value that you might attribute to the similar fact evidence. So it's a question of degree. In other words, you've got this tension. You might have some evidence of what someone has done in the past, which goes beyond mere propensity to show this is a very similar fact situation, which makes it highly probative evidence. And if it's so highly probative, then it might overcome the prejudice argument on the other side. So you can see that distinction between that which is probative, that which goes to prove something, against that which is prejudicial. Generally speaking, the balance is in favour of, if it's prejudicial, that will outweigh probative value. But sometimes with similar fact evidence, the probative value is just increased so much that it tips the other way. So, if you like, similar fact evidence is a subset of propensity evidence, and it's that part of propensity evidence which is so precise, so highly probative, that it would be almost offending good sense to leave it out and not let the jury hear about this. I hope that you're with me so far. So Fennig, the general rule is propensity doesn't get in. Similar fact evidence is so highly probative that it's really got to go in. It would offend logic and common sense to leave it out. But you can understand why I say that similar fact evidence is really a subset of propensity evidence. Have I lost you so far, or are you with me? All good? All right, well, let's kick on. So, if someone has been convicted of similar matters in the past, generally speaking, that's highly persuasive evidence to suggest that they're guilty of similar matters for which they're now charged. Or if someone is charged in relation to two matters, the question is generally, should they be heard together or should they be separated? So there's the similar fact evidence can now take on two strains, that which is the subject of a previous conviction, or that which is possibly going to be dealt with contemporaneously with another matter, which is very similar. Now, the rationale is Macon was back in 1894. There was this case of Macon against the Attorney General. Now, it was an English case, so don't worry about it. But the Privy Council outlawed the general principle of once a thief, always a thief. So that was the starting point, if you like. So the general rule in Macon was it's forbidden reasoning to say once a thief, always a thief. In Fennig, that was taken a little further to say general propensity evidence is not admissible, but we have this issue of similar fact. Now, let's actually look at the facts of Fennig. That'll give you a better idea of what I'm talking about in more concrete terms. So Fennig was convicted of abduction and murder of B, a 10-year-old boy. And between the day of the boy's disappearance and on the day of trial, he was convicted of the abduction and rape of a 13-year-old boy that had occurred 12 months after the first boy's disappearance. So the propensity evidence available from the previous trial was that the person had been lured into the van on a pretext, and there was a bicycle in the location, which was kind of similar factual situation to the other one. So the evidence against Fennig was strong, and the addition of the similar fact evidence made it even stronger. So in Fennig, even though there's this general principle that propensity evidence is not allowed, in some circumstances, if it's so high and it's so probative, then in the context of similar fact evidence, the court will let it in. Now, this is what the High Court basically said in Fennig. They said, all right, here's the general principle. Propensity evidence isn't in. And it's not admissible if it only shows that the accused has a propensity or disposition to commit a crime. That's what I mentioned earlier. Propensity evidence is not admissible if it only tends to show that this person has committed crimes in the past or has a criminal disposition. That's not relevant. That's not going to be allowed. But propensity evidence is admissible, and this is where we get into the facts of Fennig, if it possesses a strong degree of probative force. In other words, if that value of the probative value increases. And the way in which the High Court described it is that the probative force of the evidence must clearly transcend the prejudicial effect of mere criminality or propensity. So do you understand what we're getting at? In Fennig, these factual circumstances about the two missing boys of similar age were really very similar factually. Now in Queensland, the matter is the subject of statute, section 132A of the Evidence Act, deals with the admissibility of similar fact evidence. Now it only applies in criminal trials, and basically the rule is that similar fact evidence where the probative value outweighs the potential prejudicial effect must not be ruled inadmissible because it may be the result of collusion or suggestion, and the weight of the evidence is a question for the jury. So section 132A goes a little further, and it kind of deals with the second scenario that I mentioned, where you might have two people, two complainants at the same time coming forward. Defence might say, well, you can't let that evidence in because there might have been some collusion between them. Section 132A says that in itself will not be sufficient to stop the introduction of similar fact evidence where the probative value really does outweigh the prejudicial effect. I'm taking a stop just so you can take that in. I think you're with me on this. I know it's a bit tough, but I think you're with me. Now, I'm just going to detour here and mention that in Queensland, in about the year 2000, I've got to say we went off the rails. The Court of Appeal had a case of O'Keefe. I don't want you to read this because it's not the law now. But I'm just saying you might hear of this case of O'Keefe. It was the law in Queensland for a while, and it basically, I've got to say, didn't follow Fennig. So in the mid-90s, the High Court says Fennig's the way to go. Then in the year 2000, the Court of Appeal in O'Keefe decides things a different way. Then in 2006, the High Court had an opportunity to revisit this matter, and it's fair to say that not only did the High Court reinstate the Fennig test, it made some very strong adverse comments about the way in which the Queensland court had dealt with the matter in O'Keefe. So O'Keefe is out, Fennig is in, and Fennig is reinforced with greater force now by the decision of Phillips against the Queen, 2006 225 CLR 383. So Phillips and Fennig follow on from Macon, really important cases, add in section 132A of the Evidence Act Queensland, and you pretty much have your answer. You can, if you like, say O'Keefe 2000 was a diversion, but we don't follow O'Keefe any longer. So what happened in Phillips? This is the 2006 High Court case. Phillips appealed against his conviction of 3 counts of rape. It involved 5 complainants, 6 separate occasions. And the point of law for the High Court was whether there was an error of law in the repeated refusal to allow a separation of trials. And under the Criminal Code in Queensland, Section 567 provides that generally there should only be 1 count on each indictment presented to a trial court. Anyway, Phillips argued that the evidence of each of the 6 separate components should not have been admissible in relation to each of the other complaints. The court identified this as propensity evidence, which was in the category of similar fact evidence. Phillips argued that he was locked in a credibility battle with 6 people, and that left him embarrassed. So what we have in Phillips is this situation where a number of people have come forward, and the question for defence is to whether they should argue for these matters to be dealt with together or separately. And I think most defence counsel would argue to separate these matters on an indictment so that you don't have this overwhelming effect of similar matters being presented to the jury by multiple people, and the dynamic then that the jury are likely to say, well, you know, if there's smoke, there's fire. Whereas the evidence of one alone in isolation may not be enough to secure a conviction. If you have 2 complainants and therefore you're running 2 trials effectively parallel, then it might be. So the procedural aspect, the procedural rule is the defence would apply to sever the indictment so that the matters are dealt with separately rather than at the same time. Does that make sense? I'm not getting too many puzzled looks. We're okay? All right. So the basic rule is propensity. Yes, Mary? Yeah.
The one thing, I read all that, so I'm following you quite well. The one question I had in my head is, how does that apply in a class action case? Say, 50 complainants. There's currently one going on in New South Wales for 6 months, where you had like 50 women making allegations about a particular doctor, right?
I might just stop you there, Mary. I might just stop you there, only because the propensity evidence and the similar fact evidence that I'm talking about only applies in criminal law trials. Only in criminal trials. So okay. I think what you're probably talking about is compensation matters outside the criminal law sphere. Would that be correct?
No, because it was about criminality of what he did to those patients.
All right, so you're talking about this evidence.
I know it was New South Wales, so therefore Queensland law is different.
It is, yeah.
But what I was just asking, it was a criminal matter, right, that was heard for 6 months. There still hasn't been a final outcome in it. But I just was wondering how that works in, say, a class action, a similar kind of class action, because you only need a certain amount, a low number really of people to bring a class action.
Yeah.
You're making even a historical sexual abuse claim or something like that, which is criminal in nature, assault, sexual assault, whatever. So how does that fit in? That was my confusion.
Yeah, no, and no, it's a good question. I think the answer is it really doesn't, because of the different nature of the actions. Even though the class action is based on criminal behaviour, it's not dealt with in a criminal law trial. So, for example, the burden is not beyond reasonable doubt, not looking to see if someone is guilty or not. We're really looking to identify if compensation should be paid. So a different test applies, and the general rules in relation to propensity evidence, similar fact evidence, as I'm describing it now, they don't apply in a civil trial or a compensation matter.
This is in the criminal court?
Okay, yeah, I'm sorry. I'd have to look at it in more detail. I can't
Oh, that's okay. It was
Yeah.
just a point of confusion for me. Okay, that's all. Thanks.
Right. Thanks, Mary.
I'll investigate it further.
All right, thank you. All right, so I mentioned that from a procedural point of view, defence might choose to bring a severance application. And that is essentially saying these matters, these complaints should be dealt with separately, and the application is made pursuant to section 567. That's where the test in relation to joinder and severance is contained. You need to consider section 597A, and this is the criminal code now, to consider injustice, and the application itself is made pursuant to section 590AA, 590AA of the criminal code, and that will be usually in the district court or the Supreme Court. So from a procedural perspective, defence would consider a severance application, and they're the relevant sections. So I mentioned that a lot of the material that we're dealing with in week 12, which relates to procedure, I've interspersed, you might have noticed, during the 11 weeks that we've had so far. Okay, so you understand the basic cases that we need, and you've got some idea, hopefully, of the basic procedure. Have a look at section 15, subsection 2 of the Evidence Act in Queensland, because it's kind of related, and that section deals with the asking of questions tending to show that a defendant is of bad character or has committed offences. So there are 4 circumstances in which the defendant might be cross-examined, and that is where the defendant has sought to establish his own good character, or has cast imputations on character of prosecution witnesses, where the matter is probative of guilt of the offence charged, and we talked about that last week, or where the questions are directed to show another defendant is not guilty of the offence. Now, in the first 3 instances, leave is required. In the 4th, it's not. So when we're looking at this area, do consider section 15, subsection 2 of the Queensland Evidence Act. Also, consider section 132B, which relates to the evidence of domestic violence. And that section applies to criminal proceedings, and it deals with the relevant evidence of history of domestic violence, and that generally is admissible in evidence in the proceedings. So that was introduced, if you like, to bolster the ability of courts to assist those parties that were suffering as a result of domestic violence. So far we've talked about the Queensland position under the uniform laws, the Commonwealth Evidence Act. Have a look at sections 94 and 97 and 98, which deal with application and deal with tendency rule, which is, if you like, propensity, and 98, which is coincidence rule, and that's probably all you really need to know in relation to the Commonwealth sphere, because most of this type of matter, most of these matters in Queensland are dealt with under Queensland prosecutions and therefore Queensland Evidence Act. Look at your own Evidence Act in other states, South Australia, Western Australia, similar of course to Queensland, and other states, New South Wales, Tasmania, Victoria, etc., using the Commonwealth Act, which is the evidence, or the Uniform Evidence Act. All good? So you can see that there's a balancing act in all of this, and there's this general rule that people are not required to give evidence against themselves, and we talked about that last week. Section 15, we've mentioned something about it tonight as well. Now, just to digress a moment, but in a related area, is what I'll call the Sheppard Test. Has anyone heard of the case Sheppard against the Queen? It's a High Court decision from 1990, and it's Sheppard against the Queen, 1990, 170 CLR 573. Mary says yes. Good. It's an important case. It deals with circumstantial evidence. The reason I'm introducing the discussion now is that when we talk about similar fact evidence, we're really talking about something that is circumstantial. So circumstantial evidence requires the jury to consider not only the facts as proven, but inferences that might be drawn from them. When we talk about the Sheppard Test, we're really saying that the jury must satisfy itself that there is no reasonable explanation of the facts given consistent with the applicant's or defendant's innocence. That's the Sheppard Test. Now, you can understand how important the Sheppard Test is for defence counsel in particular in criminal law proceedings, because what defence seeks to do generally is to introduce some suggestion that if you look at the facts in a certain way, that then might be consistent with the defendant or the accused being innocent, which is the Sheppard Test. So the jury has to be satisfied that there's no reasonable explanation of the facts that might be consistent with innocence. If there is a plausible narrative that links the facts without the jury being guilty, then the jury must acquit. All right, so that's the Sheppard Test. And when you're considering all of this, do look at section 15.2, as I mentioned before, and the 4 exceptions that I mentioned earlier. And we talk about section 15 and the defendant going into the witness box as losing the shield in certain circumstances. All good? All right. And I mentioned section 132A. I think you need to look at that as well. Now, let's talk a little bit more about similar fact evidence. And what the courts say is, and this is the case of, this is an important one, it's an English case, it's Straffen. The Crown R v Straffen, S-T-R-A-F-F-E-N, 1952 2 QB 911. And the court in the English jurisdiction adopted in Australia is, if we're looking at something which is similar fact evidence, which is a subset of propensity evidence, in order for it to be admissible, in order for the probative value to be so great as to overcome any prejudicial effect, there must be some hallmark or some peculiarity so as to stamp the accused not only with the offence charged, but also with the earlier offences. You know, kind of a really distinctive MO. So if someone is charged with an offence with really unusual circumstances, factual circumstances, and that same person was found guilty of another offence, but with strikingly similar MO, hallmarks, and peculiarities, then that's when we're talking about the realm of similar fact evidence. And that's when we say that the probative value overcomes the prejudicial effect. Now, in the context of this, also look at another piece of legislation in Queensland. It's the Criminal Law Rehabilitation of Offenders Act 1986. Do look at section 3. And I know that I'm jumping around a bit, but the relevance of that section is that after a period of time, certain matters go beyond what's called the rehabilitation period, and there's an issue in terms of the extent to which those matters can remain or be relevant. So there's some 5 and 10 year periods there. But do just look, I'm not asking you to go into detail on this, but just be aware of it and perhaps have a look at section 3 if you're going to look at that act. Now, also consider the Criminal Law Sexual Offences Act 1978. So, and that is section 4A. Now, this deals with evidence of complaints generally. And basically it says that if someone makes a complaint, then generally it's admissible evidence. It's essentially hearsay evidence, but it's admissible. There are some exclusions that apply to it. And whilst we used to call this a recent complaint, we now tend to call these things preliminary complaints. And it's essentially, have a look at the example in the Act. That's really the best way of explaining it. So it explains that if someone complains to a teacher about a sexual offence alleged to have occurred, that might be a complaint. If they then go and complain to a guidance officer, even at a later time, that's another preliminary complaint. So there's quite distinct. If they go and see the police station and go to the front counter, that's a preliminary complaint. If they go to make a formal statement for the offence, that's not a preliminary complaint. It's kind of direct evidence. And the evidence that they, of course, give in the witness box is direct evidence as well. So don't go into it too much, but be aware of section 4A of that Act and this issue of what is a preliminary complaint and when it might be introduced and led. All good. Can I keep going? Are you still with me? Sarah's let out a sigh there. I could see that. All good? Thanks. Opinion evidence, identification and corroboration. So again, some more terms that we need to understand. I guess when we talk about opinion evidence, that's almost self-evident, isn't it? If someone gives their opinion, then generally speaking, and we dealt with this, I guess, in the first assessment, right? Doesn't the first assessment seem a long time ago that you were doing your cross-examination? Opinion, who cares? It's irrelevant unless it's an expert. Then that goes beyond everyday human experience. And the courts do need guidance from expert evidence. But of course, we need to establish that the person is in fact an expert and that the person is giving an opinion in relation to a field that is recognised as one involving expertise. So there are those aspects of it as well. You need to consider before this is actually expert opinion evidence. There might be a non-expert or lay opinion, and in fact, this occurs every day of the week in courts, where people in fact give personal opinions. It seems like it's relating facts, but it's actually an opinion. So if somebody says, "Oh, and then the accused looked frightened," well, it's really their opinion about whether this person was frightened or not. I mean, if you really, really wanted to drill down, you'd say, you'd go into detail about the facial expressions and the wide eyes and the recoil and things of that nature. But it's easier just to say the person looked frightened because we all know what that means. Does that make sense? So when we're talking about opinion evidence, we're talking about expert evidence, which is the main one, but also consider non-expert or lay opinion evidence, which is essentially admissible at times, or we let it through because it makes it a whole lot more efficient and easier. Also remember that sometimes the evidence which is accepted by a court is the subject of judicial notice, which is where the court doesn't need evidence. I know that Tuesday follows Monday. You don't have to bring someone in to give evidence that Tuesday follows Monday. I know that. You don't have to give evidence that summer is hotter than winter. I know that. That's fine. Night follows day, day follows night, etc. So all of those things are, if you like, judicial notice. And sometimes there's a fine point, isn't there, between that which is common knowledge that the jury might expect or information that they might need someone to come in and give them expert evidence about. So has anyone heard of this case of wheel against bottom? WEAL against Bottom, BOTTOM. It's an Australian case, 1966. Basically, an expert evidence was given, or expert came in. The expert was a truck driver. So not, your typical PhD type expert, but a truck driver, expert through experience, who gave evidence of the effect of a car skidding on a wet road, as opposed to the special dynamics of an articulated truck on a tight bend on a wet road, and giving the jury information about the distinction between the way in which those vehicles might act in certain or react in certain circumstances. Now, I'm going to give you an example of where expert evidence with respect to human behaviour was held to be appropriate, and then two cases where expert evidence with respect to human behaviour was held to be not appropriate. See what you think. The first is Murphy against the Queen. In Murphy's case, which was 1989, 167 CLR 94, the High Court held that expert evidence from a psychologist would in fact assist the jury to decide whether certain words and sentence structures used during a record of interview by an adult with a literacy age of 10 were really his own words. So you can see the situation. An adult, literacy age of 10 years of age, gives evidence, uses certain words and structures. So a psychologist comes in to say, yeah, that's genuine. No, that's not. We're talking about human behaviour. The court let that evidence in. That is of the psychologist. Now, where the court said, no, we're drawing the line at that, there's the Crown against Turner from 1975. The English Court of Appeal refused to allow expert evidence from a psychologist about the effect on a young man when told that his girlfriend had been unfaithful to him. The court said, no, people know that. You don't need an expert to tell us how a young man might feel or react in those circumstances. And R against S, 2001, 25A CR, Australian Criminal Law Reports, 526, where the court held that a trial judge should not allow a family services officer to comment on the behaviour of sexually abused children towards their abusers. Now, do look at the Presumption Evidence Act Section 9C in that regard. And as I mentioned before, if you're dealing with expert evidence, the first thing to do is determine whether, in fact, the person is an expert, and secondly, to determine whether the field that they're under discussion is regulated or recognised as an expert field. So when you're dealing with this area in a civil law context, you do need to go beyond the Evidence Act, and you do need to look at another body of material that may be relevant. Can anyone tell me, now I'm talking civil matters, Queensland, what is this other body of material that might be relevant when we're talking about the regulation of expert evidence in civil trials in Queensland? Marcus has said bench books, not the one I'm thinking about, and the bench books tend to be in relation to criminal law matters. Judicial discretion, says Mary. Yes, always relevant, but not what I've got in mind. Travis has got it. Well done, Travis. The UCPR is what I had in mind. So the Uniform Civil Procedure Rules are important. So look at rules 423 through to 429, and that deals with the provision of expert evidence. It deals with the way in which a single expert might give evidence. It talks about the duty of an expert overriding the obligation they might have to any party. In other words, the expert is there primarily to assist the court. That's the primary duty. That's UCPR Rule 426. And there are certain requirements to disclose reports and in some circumstances, for experts to meet. So when you're dealing with expert evidence or you're dealing with civil matters generally, don't restrict your thinking only to the Evidence Act. Always have a glance at least at the UCPR. It might be relevant. At a Commonwealth level, again, look at the at the Evidence Act. Look at sections 76 that deal with the opinion rule and section 80, the ultimate issue rule. The more important is the opinion rule, and the basic rule in section 76 is evidence of an opinion is not admissible to prove the existence of a fact about the existence of which the opinion was expressed. But there are some exceptions to that. When you're challenging expert evidence, one of the important things to consider is what are the facts upon which the expert has drawn a conclusion, and can you attack those underlying facts and the premise upon which the expert has based his or her report. That's always important. Now, one particular direction that we do see from time to time, it's significant, is the Dominican or Dominican, depending on how you pronounce it, direction. So the case is Dominican against the Queen, 1992, 173 CLR 555. Now picture this situation. You've got the wife and her husband, victims of an attack by a gunman in the driveway of their home. Imagine having gunmen in your driveway. They're in the driveway. Now the wife was ducking for cover, as you might expect, didn't get a good look at the gunman, and she gave different versions of identification, and her identification was heavily discredited. So that case gave rise to a new general rule that whenever identification is a significant factor in the Crown's case, the trial judge should give a warning to the jury, and this is the Dominican direction, about not only the hazards of identification generally, but specific points of concern in a particular case. So in other words, that direction has now built into something of its own force. So again, for defence, if you're trying to attack identification evidence, you would certainly, I think, want the trial judge to give the jury a Dominican direction. Now, one thing that we did notice in the first assessment was there were some questions as to the witness, can you identify the defendants or the people that you saw in the robbery? What was it? Discount Smokes, I think. Where are they? Yes, I can see them. They're in the dock there. Really, it doesn't make much difference because we know who's on trial. So it really doesn't add anything to say, this is the person that I saw at the time. So in that sense, it doesn't add anything. And really, it's dangerous from a prosecutorial perspective because it does risk a retrial. One other area that you might consider, I've referred you to the Queensland bench books, but a valuable resource is also, amongst others, the New South Wales Criminal Trial Court bench books. If you look at 3-010, it deals with the issue of identification, and it actually has some really good basic descriptions about what we mean by opinion evidence, identification evidence, some of the things that we've talked about this evening. Also, when you're talking about identification evidence, keep in mind another piece of legislation in Queensland, which is the Police Powers and Responsibilities Act. That's 2000, PPRA, as we call it, Police Powers and Responsibilities Act. Section 617 deals with issues to do with photo boards, videotape, and computer-generated images. We're taking a lot of material, but you're doing well. Any questions, or am I going too fast and you're not coping? You look like you're coping. All good? All right. Let's just kick on a little bit more. So far, so good. Thank you. Corroboration. So what do we mean by corroboration? Well, we mean something that is said to support the statement of another. And that might be, and generally is, another person. But you can self-corroborate. And the general rule is that you can't, it's not admissible to self-corroborate. So by you saying, and I've told 20 people this, and I'm now telling you, you're the 21st person in the witness box, the fact that you've told 20 other people doesn't matter. All you're really trying to do is corroborate what you're saying now in the witness box to make it sound more convincing. So do have a look in the Criminal Code, section 632, and there's no longer any mandatory requirement for corroboration in any criminal case other than a few exceptions. One of them is perjury. So the old rule used to be this evidence is not corroborated by anyone else or anything else, therefore we're not going to prosecute. It's now possible to secure a conviction based on the evidence of a complainant uncorroborated. So that's the general rule, but there are some exceptions. So the first is where there's an allegation that the police verbaled a confession from a suspect while in police custody, the court would be entitled and should give a McKinney direction. The McKinney direction is all about explaining to the jury the dangers of relying upon what is effectively the uncorroborated evidence of a police officer in those circumstances. The second exception is where a jury is warned about corroborative evidence based solely on eyewitness identification by a person not known previously, essentially a Dominican or Dominican direction. And the third is where a jail guard confession and the witness is a prisoner. So there is generally a requirement to warn there. Now, when it comes to corroboration warnings, there's a really important one in practical terms. It's called a Longman direction. This is fairly routine, and the Longman direction is given to a jury where there's a long delay between the date of the alleged sexual offence and the date of the trial. So the Longman direction is basically saying, look, even though this evidence is admissible about the earlier complaint, just be aware that because of this long delay, defence may be prejudiced in that it's difficult for them to counter these allegations because people that may have been available at the time, circumstances, are all different for different things. So the Longman direction, and you'll see more information about that in the bench books. So do look at that as well. All right, well, look, that might do us for this evening. You've been really good soldiering on. What I propose to do next week is deal with the issue of improperly obtained evidence, wrap up some of the procedural aspects, and then talk about the examination. So before we wrap up for this evening, any questions, comments, or are we good? All right, head's not spinning too much? Okay. One question, says Sarah.
Could you tell us what weeks we are concentrating on?
For next week?
For the exam.
Oh, for the exam? You're not going to like this.
It's a 2-hour exam, right?
2-hour exam, yes. 2-hour exam, and the examination questions are drawn from any part of the unit. But they're not difficult questions. So you need to have everything available to you. Good question though. Any other questions? All good? All right. Well, thank you for attendance tonight. We'll see you next week for our final session. All the very best. Bye for now.